to my lords,
No
that I
problem.
again don't want to repeat to.
Yes, madam.
Union has also filed a substantive SLP, that's item 44.10.
What's your?
My lords, we've given we prepared written submissions on also.
What's your grievance?
My lords, the grievance is, my lords, that without making us a party, our decision has been, and without a challenge to our decision has been interfered with. And the finding today is that NCT is not bound by the directions that central government gives to NCT. The NCT derives its power. The NCT is the authority made by a notification of the central government that they are the authority who are going to be deciding this. Well, please see, before your lordships, the merit of the decision is not there. That was neither questioned, nor examined, nor dilated on. There is no finding on the merit of the decision. What is decided by way of the impugned order is that there is no power. And please see, if I can show to your lordships the conclusion.
You can spin the field if you want to come to the merit of the decision. No problem.
Well,
because then everything is against you.
Well, my respectful submission is I am in an SLP against an impugned order passed by the High Court. And please see what are the conclusions.
Possibly your only point would be that your decision, your power has been commented upon without making.
Well, it's not just commented upon. If my lords, the central government, if it is said that NCT is not bound by the directions that central government gives to NCT, that is going to create a plethora of problems. That is going to.
That's the only point you can.
Yes, so my lords, I want to show to your lordships the final directions that came to be passed.
That is being said because in Right to Education Act there is no such provision. In NCTE Act there is a provision. Normally, in every act where such an authority is created, there is a provision. And in case there is a confusion, in case there is a date, final say will be of that. Even if it is not there, you can still argue on that, but then.
My lords, I am going to borrow the submissions that my learned colleague has made in entirety.
Yes.
On the scope of the two acts also. In our respectful submission also, my lords, there is no dichotomy in these two acts. It is not like the two acts are at variance with one another and they need to be harmonized. The 2009 Act operates on a different plane and the 1993 Act operates on a different plane. It cannot be said that the 1993 Act is at variance with, because otherwise your lordships will see 2009 Act does not prescribe qualification. And my lords, your lordships were putting that question of appropriate government also. Your lordships will see, my lords, that appropriate government is defined in section 2A in the 2009 Act. And the entire scheme of the Act, it refers to appropriate government. So wherever it wants the appropriate government to have the final call on a particular issue, that is how it is. But section 23 only talks about central government. Would your lordships kindly have section 23 again with me, my lords?
You are absolutely correct.
So section 23 leaves no manner of doubt that it is for appropriate government or who. Section 23, the power is only to be exercised by the academic authority, NCT, authorized by central government. It does not deal with any appropriate government here, my lords. Therefore, that issue may not arise here. My lords, I wanted to show to your lordships, kindly see the conclusions, the final directions that the High Court, my lords, gives in para 49, my lords. That's the summary of the conclusions. And my lords, we are here by way of a permission to file SLP because we were not a party there. We were.
Has the permission given? You were a party. Yeah. Please summarize this.
Yes, your lordships have para 49, my lords. Please see, the impugned notification of 28 June 2018 is unlawful because, number one, it is under the direction of central government, which power the central government under subsection 1 of section 23 of the RTE Act did not have. And it is not in exercise of power of the central government under subsection 2 of section 23 of the RTE Act, relaxing the eligibility criteria prescribed by NCT, nor there has been any exercise for ascertaining existence of conditions precedent for exercising such powers. The petitioner have no locus to challenge the petitioners have locus to challenge the notification merely because an additional qualification is recognized as one of the eligibility criteria. Petitioners cannot be prevented from challenging it. Now, please see, accepting a candidate with B.ed degree as eligible for appointment and thereafter subjecting him to complete the bridge course within 2 years of appointment is in the nature of relaxing of existing eligibility criteria, which the central government could have done only within subsection 2 of section 23 of the subject. Then the state government could not have ignored the notification of NCT.
Just answer one question.
Yes, madam.
You are saying that you have asked them to have B.ed as an alternative,
Yes,
right?
yes.
According to you, B.ed is a full qualification to teach in primary schools?
No, my lords, that is why the bridge course has been prescribed.
Yes. What is the use of the bridge course?
My lords,
Which means B.ed is not a qualification.
my lords, I am not getting into that argument that B.ed is sufficient to our mind also. B.ed by itself per se is not sufficient. That is why bridge course
So,
is prescribed.
you have deliberately put in a qualification which you know is not a qualification.
In public interest, my lords.
What is the public interest?
My lords, please see our letter itself of my lords 30th May 2018, which letter the NCT Act.
Please, Mr. What
There
is
are
this?
4 reasons.
Age?
I'm sorry, my lords. This letter, my lords, it's reproduced in the impugned order itself. The 30th May 2018.
Yes, 30th May.
Yes, my lords. There are 4 reasons prescribed in the letter itself. If your lordships will see para 2, my lords, and my learned colleague placed before your lordships, my lords, the minutes of the meetings, my lords, some of the other letters, the request, etc. My lords, your lordships put it to NCT. Are they supporting the decision? This is a consultative process that has gone on. And whatever difference of opinion has taken place in the consultative process has been accounted for. But finally, if a decision is taken, my lords, that decision, the central government and the authority which is nominated by the central government, we are, and this is a pan-India, my lords, it has been applied across the country. Rajasthan is the only state that did not follow the NCT notification. So my respectful submission is para 2 itself notes specifically that this is number 1, in order to safeguard the interest of the students. Number 2, the quality of education.
Which paragraph?
Well, it's para 2 I'm placing for your lordship's kind consideration. I'm just paraphrasing the reasons.
This is in which paragraph of the judgment? This particular letter?
Yes, ma'am. I'll just go. Para 16, I'm grateful to my learned
16.
colleague. I actually marked it in the compilation. There was a
Para
compilation.
14.
Para 16, the letter.
All right, the above request you're reading? The
above request, I'm grateful, madam.
Got it.
Above request has been considered in this ministry in order to safeguard the interest of the students, ensure the quality of the education. The competent authority has decided to agree with the request of KVS to recruit primary teachers with higher qualification. The insufficient number of eligible D.el.ed candidates due to low pass percentage of TET.
See, this is a problem with only KVS.
6 months.
My lords,
Insufficient number of D.el, whatever it is called,
yes, madam.
diploma, let's say,
D.el.ed.
are only for KVS. That is a problem.
My lords, that is a problem pan-India, my lords. Our
Where?
respectful submission is.
Where do you get this idea that it is a pan-India?
My lords, it has been considered in the entire consultative process.
Where?
28th May meeting says similar request has been received from Uttarakhand government also.
Uttarakhand
But
is not.
similar kind of request has been received from state.
Uttarakhand would not mean the entire country.
But there are other states also.
Where? है नहीं ना ऐसा कुछ. There was no material before you to come to that conclusion.
My lords, my respectful submission is.
KVS is fine.
My lords, if your lordships wish to see the material on the decision, I'm sure we can.
No.
The whole point we are here before your lordships, my lords, challenging a decision which has not gone into any of this. Which in fact, it was not before that the Honorable Rajasthan High Court. What was before the Honorable High Court was whether they have power. That's the aspect that has been canvassed. That is the aspect they have looked at, and that is the aspect that they have returned, my lords. So we are, my lords, today challenging the decision on the reasoning that is there in the decision. If your lordships wish to see, my lords, we have also not examined, we have not placed it before your lordships. But if your lordships wish to see the material, we'll place it. In our SLP, File application permission form.